Dear ladies and gentlemen, we would like to welcome you to today's Deutsche Börse Capital Market Partner webcast. My name is Falco Weinert from the IPO and Growth Financing team of Deutsche Börse, and I will be your moderator for the next hour. Current developments on AI legislation in the US, EU, and China is the topic of our webcast. So today, we will focus on the European AI Act, AI Liability Directive, the US AI Executive Order, and Chinese AI regulations, all of which will have wide-reaching implications for AI applications. We are pleased to have the following speakers join our discussion today. Micaela McMurrough is partner in Covington's New York office. Luo, partner in Covington's Palo Alto office, and Moritz Hüsch, partner and located in Frankfurt. I'm very happy to welcome our experts with us. As always, we expect a discussion at the end of our Capital Market Partner webcast. You can already ask your questions by using the chat, and we will address them in the discussion afterwards. I now turn the floor over to our experts. Please, the stage is yours.
Thank you, and thanks everybody for joining us today. So as mentioned, we're going to discuss the current legal developments on AI legislation in the US, EU, and China. And I'm going to get started with the United States. So US developments on AI. So really, we could spend the entire time talking about the United States on this one slide, because this slide really sums up where things stand with respect to US artificial intelligence law. So there are, four main areas of activity right now on the US side with respect to artificial intelligence. There's activity in Congress related to, federal legislation and federal lawmaking. But with respect to what Congress is doing, there are many proposals introduced by many different senators from all over the United States, and there's no true consensus in terms of any particular proposal that folks expect will pass or that people expect will get enough consensus in order to move forward in Congress. So there is a lot of congressional activity, including hearings and listening sessions and press releases about different thinking and initiatives that different congressmen and senators have about AI, but we really don't see any single federal bill that's moving forward. We're going to talk about one as an example in a moment, but at the moment right now, we're not expecting that Congress is going to pass any significant federal legislation on artificial intelligence. So the next category of laws that we need to look at are the executive orders. And it's interesting because the White House executive order was released by the Biden administration in October 2023. It was the longest executive order in history, and it spanned a number of areas in artificial intelligence. The issue with the White House executive order is that, first of all, it has lots of different priorities and competing priorities in some instances in terms of different areas of focus. And we're going to talk about those in a moment. But the second issue with the White House executive order is the fact that it is an executive order, which is that it's an order signed by the President of the United States, but it's not a law that has been passed through Congress. So because it is an executive order, the executive can pass the order and an executive can also rescind the order. So the executive order is kind of only as good as the executive is in office at the moment. So we see a lot of activity right now related to the executive order. It's just not clear where that will go in the future. Third, we have federal agency action. So we have lots of different agencies getting involved with respect to AI and AI regulation. A few of the standouts here, NTIA, Department of Commerce, and Federal Trade Commission are listed on the slide. Really, in the United States, when it comes to consumer protection, the leading regulator right now is the Federal Trade Commission. They are the ones that have come out and said, we have the authority to regulate on this under our existing authority. We do not need any special authority. We already have authority to regulate AI. And they have, in fact, gone out and brought enforcement actions and settled matters in connection with companies' use of artificial intelligence when it's facing US consumers. So they're probably the most active federal agency right now when it comes to consumer issues and AI in the United States. The other thing I will mention is that a lot of the agency action that we're seeing has been spurred by the White House executive order. So we see the executive ordering, his own agencies to take action. And again, we'll look at some examples. But we see other agencies like the FTC acting kind of on their own accord and their own authority as well. Finally, we see the last bullet, which is state legislative activity. And this activity is actually where most of the legislation is happening in the United States right now. So there's no clear consensus on a congressional bill. The White House executive order is in place, but it may not last. And it's also related mostly to the federal agencies. And we have the federal agencies acting, but in the absence of Congress, we have the states stepping in. And if you look at this slide and you look at the map of the United States with the different colors on certain states, this reflects current proposals or considerations related to AI that are active right now in the United States. So for the dark blue states that you see, those states right now are actively considering deepfake laws, so laws related to deepfakes, synthetic content, AI-generated content. The states that are in the bright pink, those are states that are right now considering election-related AI laws, so issues related to deepfakes in elections or use of synthetic content in terms of candidates, et cetera. The gold states that you see, and that's most of them, those have some kind of combined or multiple types of proposals active right now. So in the states that you see in gold, those are states that have various kinds of AI legislation that are in proposed form. And then finally, you see green, that's Colorado. That is the first passed comprehensive AI law in the United States. Utah also has a law, but it's related to Gen AI, and we'll talk about that in a moment. So, the takeaways from this slide, there's a lot of proposals in Congress, no consensus on any particular proposal, and nobody is expecting that the congressional proposal is going to pass anytime soon. We have a very significant White House executive order released last year that's spurring a lot of government activity, but does not constitute law or legislation. And then we have the state legislators active, so that's where most of the activity is right now. Okay. So moving ahead, I mentioned that I would provide an example of one of the congressional proposals. This proposal is the American Privacy Rights Act. So, when we talk about the US, we have no federal privacy law, right? A lot of our privacy laws are state-based, as in California, to the extent we have them at all. So this is sort of a different approach than the approach that we see in the EU. But the American Privacy Rights Act, or the APRA, is one of the proposed federal privacy bills that's in Congress right now. It was released just a couple of months ago in April 2024, and it aims to introduce comprehensive federal privacy legislation. As I previewed at the beginning, the consensus that we hear is that this is not very likely to pass, that there's not a big appetite right now in Congress for federal privacy legislation. The states are already in this area, and candidly, it's just not at the top of the priority agenda for Congress, and so we don't expect that this will move forward. But it's interesting to see, what the proposals look like. So with respect to privacy and AI, we see a few specific provisions of the APRA related to artificial intelligence. So one is that large data holders that use an algorithm to collect, process, or transfer covered data in a way that might pose consequential risk of harm are required to conduct an impact assessment, or would be required to conduct an impact assessment. So they have to actually look at what the impacts might be and how the tool might work in order to decide whether the impacts are acceptable. Covered entities that develop an algorithm would be required to conduct a design evaluation prior to deploying the algorithm. So here you'd have to, again, look at the design of the algorithm. Somebody would have to consider how the algorithm works and what it looks like before it's allowed to be used. And finally, I mentioned the FTC, the Federal Trade Commission. Again, they're turning out to be the leading US consumer regulator on artificial intelligence issues. And the APRA specifically contemplates that the FTC would pass rules to establish the processes by which data holders should submit their impact assessments. It also contemplates that the FTC is the entity that would decide whether certain companies or tools might be excluded from the Act's requirements. So the FTC would be the rulemaking body under the APRA. So that's just one example of the legislation, the congressional proposals that we see in the US. But again, folks are not expecting that it's going to pass. So I also mentioned the White House executive order. So the White House executive order was released last fall. It was hotly anticipated. Folks waited months and months for it to come out. And when it did come out, it was not disappointing because it was very, very long and it covered lots of different territory. And the way the executive order is organized, it is the executive order lays out 8 guiding principles for the White House policy on artificial intelligence. And we've listed those principles on the slide here. We'll talk about a few of them. But basically, the White House says that, with respect to the US government, these 8 principles are important to us. And these are the principles that we are going to try to push forward through executive action. So through action at the federal level, but according to the federal agency. So again, this is not law under Congress. It is the White House saying this is part of our policy. First, the first priority is safety and security, right? So let's let the AI hurt people, make sure it's secure, make sure it's safe, it's not going to injure people, et cetera. That's number one. The US wants to promote innovation and competition. So, it's well recognized that when regulation happens, that it has the potential to stifle innovation or to chill innovation and investment. And the White House specifically says that it doesn't want its AI policy to do that. It still wants to promote innovation, but just within these guardrails. The US White House wants to support American workers, right? It's concerned about labor issues and whether AI may replace jobs or whether there may need to be retraining in the American workforce. It also talks about equity and civil rights, so obviously historic discrimination concerns at issue, consumer protection, which we already talked about, is being forwarded, through the FTC, privacy and civil liberties. So a concern that use of certain AI might cause, privacy concerns or raise issues with civil liberties. The US also wants to put boundaries around the federal government's use of AI and have requirements for the kind of AI that the government uses. And finally, there's a section called US Government Leadership on Global Progress. This is really about working with allies. The US has made clear that it does not want to go it alone with respect to AI policy, that it wants to align with like-minded countries, with allies who share, values, and proceed with developing and generating responsible and helpful AI along with our allies. So the White House is really interesting, and the executive order is really interesting. Right now, it's being implemented, right? So it came out last October, and it assigned different jobs to different agencies in order to carry forward the 8 principles that we just talked about. So on this slide, we have a couple of examples of some of the requirements that the executive order imposed on federal agencies. So the Department of Commerce, is developing reporting requirements for companies developing dual-use foundation models. The NTIA is examining risks and benefits of dual-use foundation models with widely available weights. And it's identifying standards for labeling synthetic content. So that's deepfakes, right? AI-generated content. NIST, the National Institute of Standards and Technology, they're turning out to be a really important agency when it comes to AI. They have the AI risk management framework in the US, which is the leading AI risk management framework. But as part of the executive order, they're also ordered to establish guidelines for red teaming and release draft publications. And then, we also have the OMB, who released guidance on federal agency use and procurement of AI. So to the extent the US government and federal agencies use AI, they want there to be transparency and they want it to be responsible. So, again, just in terms of agency action, we wanted to give some specific examples on, what the agencies have been doing. So NIST, again, creating guidance for how organizations can detect synthetic content, really important, detection of deepfakes, especially when they're not labeled or identified. The FTC, they're the ones in the middle, again, leading consumer regulator on AI in the US. They're issuing guidance to companies on deploying AI, guidance on minimizing deception with respect to use of Gen AI, again, that synthetic content issue. And then you also have the FCC, who is the Federal Communications Commission, and they are releasing rulings and guidelines about robocalls, texts, artificial and synthetic voice content, et cetera. So lots of activity at the federal government. But as I mentioned on the first slide, right, we have the congressional activity. We talked about one example. We have the White House executive order. You have the federal agency action under the executive order and independently. But a lot of the real activity in the US is at the state level. So in the states, we see both state legislatures that are active, and we also see the executive, so the governors of the states, and their state AGs, their state attorneys general, proposing legislation, passing legislation and guidance about AI. And the thing with the states is that with the exception of Colorado, we don't necessarily see comprehensive AI frameworks being adopted in every state. We see that every state cares about slightly different issues related to AI. So as I mentioned at the map at the beginning, some states care about AI use in elections. Some states care about deepfakes. Some states care about generative AI. Some states care about AI in employment, AI in insurance. Some states care about facial recognition technology. So they're really all different concerns that we see at the state level reflected in the proposed state bills. So we're going to talk now about some of the trends that we see. So even though we see a different approach from different states, we do see some common themes across the states. So for those states that are presenting and proposing AI legislation, we see the following: notice requirements. That includes notice requirements when you're dealing with an AI tool. So for example, an AI chatbot, or a notice requirement when there's synthetic content. We see requirements for impact assessments. So we see requirements that before AI is deployed in a particular industry or use case, that an independent impact assessment be performed. And sometimes the results of that need to be filed or made public. We see concerns about individual rights. So we see limitations or requirements like impact assessments or disclosures related to contexts like lending, housing, healthcare, when there are individual rights at stake. We see states using their licensing and registration regimes as hooks in order to bring entities under the purview of the state legislature. So some of the state laws that we see basically say, if you are licensed, in this state to do certain work, then you fall under our AI law. And finally, I mentioned Gen AI and content labeling. So disclosures about when you're addressing Gen AI, and also disclosures about synthetic content. So two specific examples that we wanted to touch on quickly with respect to US state law. So one is the Utah AI Act. So this act took effect on May 1st, 2024. So I want to mention this because this law is in effect right now as we speak. And it's called the AI Policy Act, and it's related to generative AI. So what this law does is this law has disclosure requirements for entities that are using AI and that are regulated entities in Utah. So it requires disclosure at the outset in certain regulated occupations. So if you're engaged in these regulated occupations, financial advisor, physician, these regulated industries, and you're interacting with a customer using AI, you must disclose that at the outset of the interaction. For others, if you are interacting with AI and you're not in one of those regulated industries, you have to disclose that you're interacting with AI if asked by the individual. So for regulated occupations, there's a mandatory disclosure at the outset. And for other regulated entities, but not in those regulated occupations, you have to disclose if asked. And so basically, it's like making people aware that they're dealing with AI. Second, the law provides that companies have limited availability to blame AI for statutory violations. So for example, there are civil rights laws. If an AI tool spits out a statement or makes a decision that would constitute a violation of that law, it will not be a defense under this law to say, well, the AI made a mistake. The AI made the statement. The AI made the decision. You are not allowed to blame AI. Companies that deploy the AI have to be responsible for the decisions that their AI makes. So with respect to enforcement, you can see here that this is enforcement by the government. There is no private right of action, and violations of the act are subject to fines up to $2,500 per violation. The act also establishes an Office of AI Policy and an AI Learning Lab where companies can test, we can work with the AI Learning Lab to test their products and policies. So it's sort of a public-private partnership. And again, this law related to Gen AI is in effect. The second law I want to talk about is the Colorado AI Act, or CAIA. This law is passed, but not yet in effect. It goes into effect on February 1st, 2026. So we have a long way between now and when the Colorado Act is in effect. This law is a little bit different. As I mentioned, it is more comprehensive, so it's not limited only to generative AI. And it relates to any AI system that makes or is a substantial factor in making a consequential decision. So something important, right? Something important. So what does something important mean? Well, under US laws, it typically involves either safety and security, or it involves one of these areas where there is some right at stake. So for example, education, employment, housing, lending, healthcare, insurance, many of those are sort of regulated industries. So if you are making a decision about those things or safety and security, that is likely to be a consequential decision under the Act. So, you know, what does the Act impose? Well, it imposes a duty of care. So it says if you're going to do this, you have to do it carefully. And it also imposes obligations on developers, the people that develop these models, and the deployers, right? So the developers have to make a bunch of disclosures, including different statements about how the model was developed and how it's evaluated, and reporting incidents of quote unquote algorithmic discrimination. And then developers must provide notice to consumers about the fact that an algorithm is being used and an explanation of adverse decisions. So if the tool makes a decision against a consumer, the deployer has to be able to explain that decision. And again, this is enforceable by the Attorney General, and there are limited exceptions for small employers. Finally, I just want to talk briefly about litigation related to AI in the United States. So the US, you know, as folks might know, we have a rather litigious system here. We have lawsuits quite frequently, and we are already seeing lawsuits related to AI. So the litigation theories that are most commonly seen with respect to AI are the theories that are on the slide here. So, you know, defamation, the Gen AI produced false information about an individual. IP infringement, the Gen AI trains on intellectual property owned by somebody else or produces an output that's similar. A violation of civil rights related to AI. Again, the AI made a decision and it denied me housing as a result. Product and tort liability. So the AI hurt someone and now I'm suing you because I was hurt by your AI tool. And finally, you know, contract claims. So I was running your AI and you promised me that it wasn't going to do X, Y, or Z, or that you weren't retaining my information, and then you were. So these are the common lawsuits that we are currently seeing in connection with AI in the United States. And with that, I think we're going to have time for questions at the end, but I'm going to pass it along to Moritz to talk about the EU AI Act.
Many thanks, Micaela. Yeah, in the European Union, the AI Act will enter into force quite shortly. The Council, the Parliament, and the Commission have aligned on a text, and now the next step will be that the text will be published in the official journal, and then there will be 20 days, and after the expiration of these 20 days, the Act enters into force. However, there will be a transitional period within which the obligations of the Act become binding step by step. The first set of obligations become binding after 6 months after the entry into force date, and this relates to prohibited AI. Whereas the longest period applies to the obligations of high-risk AI systems. Those obligations become binding after the expiration of 3 years after the entry into force date of the AI Act. So substantively, the Act establishes rules on the development, placing on the market, and use of AI systems across the European Union. And as many other regulations, most importantly the GDPR, also the AI Act will have an extraterritorial scope. For example, it will apply to AI systems that are placed on the market or put into service in the European Union. It will apply to output of AI systems used in the European Union, irrespective whether or not the provider or deployer is actually located in the European Union or not. So the players within the AI Act ecosystem that are regulated are providers, that's the terminology for developers in the AI Act, deployers, so persons or companies who make systems available. For example, an employer will be a deployer if it makes available AI systems to its employees. We have obligations for importers and distributors, product manufacturers. We have authorized representatives, which we also know from the GDPR, and affected persons. So with the AI Act, the lawmakers have taken a risk-based approach, and you can see from far left to far right, there's a minimal risk that applies presumably to the majority of AI systems in the market, which will not be regulated at all. And on the other hand, we have unacceptable AI, which is banned, which is prohibited. And I mentioned it will become binding after 6 months after the entry into force date. And this applies to manipulative and exploitative practices, to social scoring by public authorities, and also to real-time remote biometric identification systems used for law enforcement. However, there are some narrowed exceptions with respect to the latter. In the middle, we have high-risk AI systems, and this is really the core of the AI Act. We will explain, or I will explain in some minutes, a bit what types of systems qualify as high-risk systems, AI systems, and what obligations come along with that qualification. We have AI systems that only triggers limited, mostly transparency obligations, like chatbots, other generative AI systems. They mostly the providers and deployers have mostly to comply with transparency obligations. And top right, you see the general purpose AI models. This is a category that has been introduced pretty much at the end of the legislative process. And models are trained by large data sets, by large content. They can be used for a variety of purposes and will be typically built in downstream applications by AI systems providers. So a model is different from a system. A model is a layer down, so it will be built in a system, and then the provider will market the system to deployers and others. Okay, and for high-risk AI systems, there are basically 2 different categories. The first one is that the system is either a safety component of a product or is itself a product that is covered by union harmonization legislation, and those products are required to undergo a conformity third-party assessment. And examples are machineries, medical devices, toys, lifts, etc., also vehicles, but interestingly, the AI Act will not apply to such safety components or to autonomous cars itself. Rather, the lawmakers have to introduce AI-specific requirements into the type approval regulation by means of delegated acts and by other legislative acts. And then there's a second category of high-risk systems that is a more open definition, and high-risk AI systems can be systems that are used for biometric identification and categorization of persons, that are used within the scope of employment, workers' management, and access to self-employment, or that are used for access to essential private or public services and benefits, including when they evaluate the credit worthiness or when they establish credit scores. Okay, and if you are a provider of a high-risk AI system, so you have developed that system, then you have to comply with a broad range of quite challenging obligations. We have listed them here. We won't go through all of them just due to the time constraints, but you can see at first glance that these are quite onerous obligations, like implementing a risk management system, creating and updating technical documentation. You have to make sure that the AI system is capable of taking and keeping records and logs, so that later one could have a look at these records and logs if something went wrong. You have to issue instructions for use, and you have to make sure that the AI system is capable of being overseen by a human. And on the right column, you have to do the conformity assessment if that is applicable to the product. You have to register your high-risk AI system, and even if you have put this on the market, you have to comply with post-market monitoring obligations. So really quite onerous obligations. And now you have if you are the provider of a high-risk AI system, there are 3 years to implement these requirements. And on the other hand, if you are a deployer of a high-risk AI system, for example, an employer, a company who makes available certain AI systems to its employees, then you have also quite far-reaching obligations. Among other things, you have to make sure that the AI system is actually overseen by a person when it is used, to make sure that there's always a human component in it. You have to report risks and serious incidents. You have to keep the logs that are generated by the systems. You have to submit annual reports, and you have to inform natural persons that they are subject to the use of high-risk AI systems. And in some cases, you have to also conduct a fundamental rights impact assessment. Again, these are not all the obligations, but just to name a few and to illustrate how far-reaching the Act is. Okay, and as mentioned, there is also this new type, the providers of general purpose AI models, which can be built in systems. And also these providers have obligations, so they have to draw up and keep up to date technical documentation, and they have to make available to AI system providers information and documentation so that the providers can actually implement the model into their system. They have to put into place a policy to respect and honor EU copyright law, and they have to prepare and make publicly available summary of the content that they have used to train the AI. And when they are not located in the European Union, they have to appoint a representative. And there's also a second category of general purpose AI models when they have a systemic risk, and these AI models with systemic risk come along with even far-reaching obligations. Okay, and this one illustrates the obligations of providers and deployers of non-high-risk AI systems, where you have mainly transparency obligations. This is, for example, if you have developed a chatbot, then like ChatGPT, you have to design this system in a way that the natural persons can be informed that they interact with an AI system. If you are a provider of an AI system that generates audio, image, video, text, then you have to make sure that the output, so the video or text or whatever that is, that this is marked as artificially generated or manipulated. And if you are a deployer of an AI system that generates or manipulates images, audio, or video, or text, but only text that is published to inform the public on matters of specific interest, then you have to disclose that the content has been artificially generated or manipulated. Okay, on the last slide, just very briefly, the enforcement regime under the AI Act. So the AI Act introduces a number of new bodies, for example, the AI Office, which is, among other things, competent for coordination. There will be a board that will advise the Commission. There will be also an advisory panel and scientific group that will advise the Commission from a scientific perspective. However, the enforcement itself will take place on a member state level. So member states have to determine the authorities that shall be competent to enforce the Act, and the enforcement under the Act can be quite tough. So as the GDPR, there can be very high fines. The ones in the AI Act are even higher, so they can go up to 35 million or a fine 7% of the total worldwide annual turnover. So very high, potentially very high fines. Okay, this was a very brief overview on the AI Act, and now I'm happy to hand over to my colleague Jan, who will talk about the developments in China.
Thank you, Moritz. Great to talk to I'll talk about a little bit. We start with a general overview on the developments in the Asia Pacific region, but we are obviously focusing a lot on China because it's one of the jurisdictions that's probably going to be most challenging, but at the same time has a lot of potential in terms of AI developments. To start with, we'd like to show a slides just to make sure we have the sort of the overview of what is happening in the Asia Pacific region. As you can see that many countries in the region actually come up with either specific AI regulations, which obviously the most obvious example is China, but other jurisdictions are at least discussing or sort of proposing some kind of AI specific legislations, such as Taiwan or South Korea. But we also see many other jurisdictions that are either relying on the voluntary, non-binding, principles or guidance or strategies, however countries calling it, to sort of try to steer the development of the AI while at the same time considering some of the regulatory, how the society should regulate AI development. We see many countries, as you can see that, from these slides, there's quite a bit of countries that are having, either AI principles, ethics principles, or strategies, or some data privacy regulators, some banking regulator, financial services regulators are also issuing some of this specific guidance here. So I think at the high level, it's fair to say that while there are a few Asian jurisdictions are considering AI-specific laws or comprehensive requirements for AI. Most of the jurisdictions are still at the very early stage of the regulatory developments, and the governments are in generally much more focused on the helping the industry to develop a more the AI technologies and trying to manifest the efficiencies or the gains that the new technology could bring to the society. So that's kind of the high level, and that sort of sets a tone for a lot of the developments that in China, that in the Asia Pacific region, but also where you can see actually why China is an example of specific regulations that has been rolled out, and how this is probably going to be a path for other jurisdictions as well. Coming back to China, so actually China is one of the first jurisdictions that had a comprehensive regulation, which took effect on August 15th, 2023. So if you remember, that's just a few months after the sort of the ChatGPT phenomena rolled out. So it was one of the earliest regulations that are trying, taking a crack on the regulating AI, especially generative AI services. So there has been, but I wanted to mention that, starting in when China rolled out the generative AI regulation, they actually had previously regulating some of the other types of, machine learning or AI, specific technologies, such as the deepfake regulation, which was already issued in January 2023, and then the regulation related to algorithm recommendation for, for example, e-commerce or other social media sites, that's already being issued in March 2023. So it was, China has a track record of trying to regulating new technologies when it comes to, and this generative AI service regulation is one of those examples. The other thing that the Chinese regulator has done over the years is also to issue a lot of the non-binding national standards that are sort of accompanying the regulations. So there has been many national standards that has been released. Some of them related to the security requirements for generative AI services. Others are requiring related to, for example, tagging of the content, for AI generated content. Also, there's quite a bit of regular standards, either in draft form or has been deployed, related to the training data set of those that can be used for the generative AI services. So with that, we can talk about some of those specific considerations for China that is probably more practical to companies. So there's a delay in flipping the slides. Just a moment. Yes. So there's, as I mentioned, in practical terms, when companies are considering either to deploy or to either to develop or to deploy generative AI services in China, there's a few things to consider, right? So the first thing to consider is actually under China's generative AI regulation, whether there's a need for the company to conduct a security assessment and algorithm filing to the regulator. So this is one thing that usually companies will have to think about the first. So the scope of the regulation is actually very specific. I wouldn't say narrow because it's not, in the sense it's not narrow, it still covers a wide range of AI applications, but it's specific in the sense that the regulator would only require those AI applications that are to the public, offered to the public in China, to conduct a security assessment and or algorithm filing. So in other words, so this is a pre-market requirement. So if you are considering, for example, rolling out a chat box to offer to, like, for example, customers, or in the healthcare sector like patients, or in other sectors, just some kind of to the consumer facing part of the business, then that is something that has to be thought about. The generative AI regulation in China actually explicitly exclude anything that is related to enterprise use. And then that's, so if it's a API for enterprise use, or it's a solution that is only used by large enterprises, it's relatively, I mean, so far the practice suggests that it's not a security assessment or filing is not required with the regulator. So that is the first step. Usually when you think about whether even the regulation would apply to the service or not. Then the next one that we usually think about is that content moderation and tagging. It is the as I mentioned, there's regulation and there's also national standards as to how to tag AI generated content, and also there are also very specific technical requirements as to say, for example, if the service is transitioned from a human to an AI generated response, or the other way around, then how should this has to be clearly flagged so the consumer or the users would know that they're talking to a AI powered chatbot or agent. So that's one thing that usually when you are doing the security assessment or the filing, the regulators will probably like to think about. There are also other requirements such as, their pre-training data will have to be, both the pre-training data and fine-tuning data will have to be meeting certain requirements. Again, there are national standards on that, and usually the regulators will think about it, how, when you're requiring to do the security assessment. Finally, we wanted to mention that there's a big component of that is also the cross-border data processing and also on China's cross-border data transfer. This is usually related to if, for example, you wanted to develop AI services or algorithm that is trained based on the China data. So just, data generated from, for example, Chinese patients or Chinese or other data generated in China, then there's usually have to consider whether, how to address the cross-border data transfer issues, right? So in general, just to, for a quick background, that personal data, any type of personal data, if it's there's certain requirements under China's personal information protection law. So it's similar with GDPR, where you would have to say, well, if there's a transfer mechanism that I have to use, or this is, transfer is based on consent or other requirements. So there's cross-border data transfer requirements there to always to think about, especially if there's certain development is happened in China for AI application or solution. With that, we can just probably see that, most, this is again like a different approach of the AI governance in the region beyond China. So China obviously has a regulation that has already been adopted and enforced, but there are more countries that are sort of starting to consider to have AI, AI-specific legislation or regulation. So Thailand and Vietnam is the sort of more recent examples. And then other jurisdictions, as I mentioned, including, for example, Japan, are still considering like voluntary guidance to AI development. For example, in Singapore, there's also been pretty active. They quite a few ministries of the Singaporean governments that issued guidance and trying to promote the use of AI. So this is the same for as I mentioned, as you can see from the first slides. So this is to sort of recap what we have discussed here. So the trends in those countries, other than China, obviously, is that government focusing on promoting AI use and development. So some of the AI-specific laws has been proposed, but in the very early stage, and many other countries focusing on high-level voluntary and principle-based guidance. And the third one is privacy regulators. Financial services regulators may play a role in those AI governance, especially when there's no specific laws that are related to AI. China obviously has gone through a different route, and the most active Chinese regulator in this space is the Cyberspace Administration of China. But as I mentioned, the Chinese regulation actually has a very specific focus, and most of the enterprise, essentially all the enterprise used, solutions are not covered. Obviously, it's there's a sort of gray area with to, what is enterprise use solution and what is sort of a to the public. It's not very well defined at the moment, but in general, that's sort of the intention of the regulator is to focusing on those that are to the public, that has a sort of a content moderation requirement for those applications. With that, I'm turning this back to Moritz, and we can see if there's any other questions here.
Perfect. So yeah. So first of all, thank you very much for this interesting presentation and valuable insights. We have already received the first questions, so maybe Moritz, I think the first one is for you. So how do the AI Act and the Data Act work together?
That's a good question. So first of all, both acts are part of the Commission's digital strategy, which encompasses various new regulations, including the AI Act and the Data Act, but also the Data Governance Act and others. And as we have explained in this presentation, the AI Act focuses on the risks of AI systems and regulates the obligations, whereas the Data Act has the purpose to give users more comprehensive rights to access their data, to request the handover their data, and also to further use their data. And this applies to both personal data and non-personal data. But often when you will provide let's say, a connected product, like an IoT product, which embeds AI, then you will have to comply with both acts, which can be quite challenging, because the Data Act says that you have to also make available the data that the product creates, and this is not really clear how this relates to processing by an AI system, where it's sometimes very difficult to hand out the data itself. So both laws can apply together with other laws. So the GDPR, for example, will also apply, but both laws can apply to when you, for example, when you sell or otherwise make available connected products.
Mm-hmm. Okay, thanks. Micaela, the next one could be one for you. So it sounds like the Federal Trade Commission could emerge as the primary regulator of AI in the US. Is it right? And if so, what sort of actions and remedies can it take or impose?
That's a great question, and whoever asked it, somebody was paying attention. So the FTC is certainly, they certainly think of themselves as the primary AI regulator in the US. And of course, they regulate consumer fairness and the absence of consumer deception. So really any business that's consumer facing can end up in the crosshairs of the FTC. So they have taken the position that they are the primary regulator, especially with consumer businesses, and as I mentioned, that they have the authority to regulate under their existing laws, under Section 5 of the FTC Act. So they don't need additional authority. So the fact that there's Congress is stalled and the White House executive order is in progress, but somewhat uncertain, doesn't affect them, because they've taken the position that they can regulate under their existing authority. So they've been pretty aggressive about that. And I mean, the good news there is that we do have some guidance about what they think is appropriate. So for example, if you have an AI tool that is suddenly going wrong or producing incorrect results and you find out about it, they've taken the position that you cannot do nothing. You have a duty to act in those circumstances. But at the same time, as Congress progresses, if there is some bill that ends up getting consensus, and as other regulators catch up, particularly those in highly regulated industries such as financial services, healthcare, FDA, then those regulators might sort of catch up to where the FTC is now. But for right now, especially for consumer-facing businesses, all eyes are on the FTC with respect to what they're doing.
Mm-hmm. Thank you, Micaela. Are there any US export control or sanction rules specifically targeting making AI software models available in China, or developing or training such AI software models in China? Maybe Jan, you want to answer?
Sure. Yes, it's so I think the other sort of elephant in the room is that there's a lot of the geopolitical tension around the US-China developments, right? So in terms of the AI development, so far the export control rules are mostly related to the most advanced of semiconductor chips. That that's controlled by the export control rules on the U.S. side. On the model itself, or there has been a lot of discussion in which sort of we expect that there will be rules around it on the export of the most advanced, foundation models, including the weight of those models, or or other aspects of the models that could potentially be subject to the control of the U.S. trade rules. But so far, as we speak right now, they only the chips and also the equipment, the making chips and other semiconductor related controls are in place. We do expect to see more, and so this is definitely an area that has to be watched more closely.
Okay. Thank you very much for the explanations. We are now coming to the end of our webcast for today. So all participants will receive the recording afterwards. Thank you very much for watching and for your interest in the topic. And of course, I would also like to thank our experts. So have a good day. We hope to see you next time again.
Thank you.